The Supreme Court upholds the right to privacy. This is the first bit here that is coming in. Vinay, step in here, help us understand what this means on these arguments here that have taken place.
The reporter is saying that the judgment is over, which means they have finished pronouncing it, which obviously means that it's a unanimous verdict, because they have just read out what every single judge on that bench has agreed to. And if this is correct, then it says that Supreme Court has upheld the right to privacy as a fundamental right. Now, This is very, very, very big. It is simply big because now, unlike the past, where right to privacy was a subset of right to liberty, now you have right to privacy as a separate individual fundamental enforceable right. And it is huge. And it's obviously huge because it will have serious ramifications on several issues in the future and the ongoing cases in the court related to Aadhaar, even previous instances like the Nas Foundation case of Section 377.
It puts an end to a debate that whether it is fundamental or not. However, as we have always all been saying, that there could not have been any doubt or there could not have been any two opinions on the fact that there is an inherent right to privacy within Article 21, as the Supreme Court has said. Life and liberty include right to privacy. But the real question, as we have all been saying, would be to decide the extent or the contours of this right, as to what extent the Parliament by law can put restrictions on this right, or to what extent the Parliament by law can allow the state or the private players to go to secure or procure that information. Now, all that, in fact, according to me, there'll be many rounds of litigation now on many issues, as you and everyone else amongst us keeps on raising questions. What happens to Aadhaar? What happens to the bank accounts? What happens to other? So all these things will have to be now again decided by the courts only. And in fact, what can be done, what can be really done to put an end is by the legislature only. The legislature must step in now, and just like the Right to Information Act, the legislature came in and it had to quite a large extent put an end to the controversy. To this also, the legislature has to come in and decide the contours of this act, this particular right, and decide to what extent an individual can hold back the information. That would be the right question. Actually, if you see, before the Right to Information Act, there was a large debate on as to what information the state can hold back, and it was always said that the state has to claim right to privilege to that information. So it is something like that only, that a citizen has to kind of claim privilege to that information. The citizen has to say that, okay, this is going to damage my reputation, this is going to damage my life, this can create danger for my family, for my property, and therefore I should not be allowed to disclose this information. But if it is in the national interest, or if it is to safeguard the life of another individual, then there cannot be any doubt that there can be a restriction or there can be a limitation prescribed by the law to that particular right. So all these things need debate. They will have to be decided by subsequent judgments. So it is not an end to the whole story.